Hello and welcome to the Cook County Board of Review's attorney meeting and information session where we will take the time to explain to you what you might expect as we move forward into the 2021-2022 filing season. Before I begin, I want to acknowledge the fact that we've all been through a very challenging time with the COVID-19 pandemic, but I want to thank the Board of Review staff for their hard work and dedication. Because of our technology upgrades over the last several years, we were able to convert our in-office process to a completely remote process, really without skipping a beat. And that's in no small part due to the hardworking staff at the Board of Review. So I'd like to publicly thank them and acknowledge the hard work that they do and they have done every year. Going into this season, there will be a few changes, but we expect this to be a successful session. A part of it being a successful session is our office taking the time to explain to you our expectations and our needs with regard to your filings, and to hear from you about ways we can improve the process to make it as efficient and effective a process as possible. We are a taxpayer-friendly office. We like to remain a taxpayer-friendly office. And so we want to make sure that we hear from taxpayers and those that represent them about ways in which we can improve the services that we provide. With that, I'm going to turn it over to the staff. But again, I want to thank you for your participation in this information session, and we look forward to your input.
Hi, everyone. I'm Commissioner Tammy Went, and I wanted to say welcome to the 2021 session. I also wanted to say thank you so much for your patience in 2020. I know it was a difficult year, and we appreciate all of your hard work and patience. I look forward to working with you in 2021 and the years to come, and hopefully we can meet in person soon. But until then, stay healthy and enjoy the rest of your summer. Thank you.
Hello, this is Commissioner Michael Cabanargi of the Cook County Board of Review. I wish we could be together in person, but I appreciate the opportunity to speak with you here today. I'd first like to thank my staff for all their hard work in 2020, for their continued dedication and professionalism throughout this pandemic. With this continued pandemic and now the triennial reassessment of the City of Chicago, we're gearing up for the highest volume of appeals we've ever seen at the Board of Review. Accordingly, please pay close attention to our rules, deadlines, and the other information that William O'Shields is about to share with you. We're counting on your professionalism to help us render fair decisions for everyone in Cook County. In particular, we'd ask that you choose your hearings wisely, and whenever possible, choose administrative no changes in your appeals. Once again, thanks for your time today. If you have any questions, you always know you can reach out to us at the Board of Review. Together, we can help see to it that taxpayers in Cook County pay only their fair share in property taxes and not a penny more. Thank you.
Good morning. This is William O'Shields. I'm the Chief Deputy Commissioner of the Cook County Board of Review. I'd like to welcome you to the 2021 Attorneys Meeting, and I'll be your presenter. But before I begin, I must acknowledge the leadership of the board. And I'll start with the 1st District, which is Commissioner Tammy Went, 2nd District, Commissioner Michael Cabanargi, the 3rd District, Commissioner Larry R. Rogers, Jr. Along with that, I would also like to recognize the First Assistants and Chief of Staffs of the Commissioners, Todd Thielman, who is the First Assistant to Commissioner Went, Roland Lara, who is the First Assistant to Commissioner Cabanargi, and Demetria Burris, who's the Chief of Staff of Commissioner Rogers. Also, I must recognize the Chief Clerk, Alan Manuel, and James Thompson, the Secretary of the Board. But more importantly, I would like to recognize, acknowledge, and celebrate the hard work and commitment, dedication, and sacrifices of the Cook County Board of Review employees, who without the level of commitment and professionalism, a successful 2020 tax year session would not have been possible. Today's agenda will cover the following topics: the data subscription service, which proved to be highly successful, board rules and requirements, the oral hearing procedures for the 2021 session, certain DAPS enhancements, recommended best practices, the attorney substitution checklist, exemption procedures, the types of complaints that still must be filed at the counter, the unauthorized practice of law, and opening dates for Group 1. Due to COVID-19, the board held the entire 2020 appeal session remotely. The last on-site day for the board staff was March 16, 2020. For the 2020 year, the board adjudicated over 223,000 appeals, a slight drop from the last South Tri in 2017, which was approximately about 218,000 complaints. Now, due to the assessor's delayed reassessment schedule for 2020, the board finished its assessment appeal review on June 10th, 2021. Please note that the board did not receive any townships prior to September and received the majority of the townships in the last 3 months of the calendar year, that being October through December 2020. Essentially, we received 216,000 of the 223,000 complaints from October to December 2020. In addition to moving the analysis of appeals to a remote environment, the board's clerk and IT departments developed a remote hearing process for any requested assessment appeal hearings. The board leveraged Cook County technology and held hearings through the use of Microsoft Teams and via telephonic hearings. The clerk staff also incorporated a case management system to proactively contact appellants who had requested hearings and explain the appeal process, evidence submission, and any other not value questions. This process was very successful in providing a more robust level of services to Cook County residents and allowed the board's analysts to focus on valuation details of an appellant's appeal. As a result of this, the number of pro se appearances was reduced by over 50% through the newly implemented process. The efficiencies and increased level of service created by the newly enacted system will continue after the reopening of the county and the board of review. All hearings for the 21 tax year session will remain remote. Now, please note that this year is the reassessment of the city of Chicago, and it demands that the session be finalized by mid-May 2022 to allow for July 1st mailing of the second installment tax bill. Now, a copy of this presentation and a more detailed description of the board's procedures will be available on the board's site. Go to the home page and click on See All Guides. The objective of today's presentation, in a very broad sense, would be transparency, predictability, and consistency. I'd like to begin today's presentation with discussion of the board's data compilation subscription service. Please note, for 2021, the subscription service will include the following: a compilation of assessment data in a custom web page that will reference each appeals and board's notes, board summaries, and board result letter. In addition to the web page, the batch will also include a spreadsheet containing all relevant result data based on specific groups of townships as determined by the board. Also, it will provide a point of access to data result data within the subscriber's DAPS account, which is accessible via the portal or via a secure file transfer portal site. And for example, see the board decision letter batch. The subscription service fee structure is based upon the historical board filing frequency over the last 3 years. It is solely within the discretion of the board to determine the subscriber's appropriate tier based upon the aforementioned historical data. Presently, the filing frequency data is being updated to include the 2020 session, and we will delete the 2017 session data. After this data is compiled and analyzed, the tier structure will be adjusted, which will be memorialized in the forthcoming 2021 data subscription agreement. Your subscription service will be activated after the forthcoming subscription service agreement is fully executed and the annual subscription fee is paid in full. There are certain benefits of the board subscription service, one being electronic spreadsheet, one-click access, and improved efficiencies and automation. As an added feature to the board's subscription service, the board implemented a bulk filing utility, which streamlined the appeals filing process and improved subscribers' labor cost efficiencies. Said improved efficiencies are achieved by providing subscription users the ability to file complaints and upload supportive valuation evidence in bulk. Next, I will discuss the board's rules, requirements, and procedures, which includes certain revisions and the enforcement of existing rules, the mandatory historical summary form, intervener valuation rules, and exemption rules. Let's start with the revision of certain board rules, and we'll start with Board Rule 2, which was revised to include the following language. The attorney authorization form must be submitted before the finalization of the board complaint via its online system or at the time of the complaint submission. This is to address the issue of the taxpayer representative showing documentation that they're authorized to proceed on the behalf of the taxpayer at the time of filing. This will also include pro bono filings. And so let me just elaborate on that. And looking at the particular comment is that the attorney authorization form must be submitted with all board complaints submitted by attorneys who have a current board attorney code, including pro bono filings. In addition, the initial submission of an attorney authorization form at re-review does not comply with Board Rule 2. In addition, we're looking at Board Rule 3. Failure to follow any rule may in itself be grounds for denial of any relief. More importantly, the board may also, for repeated violations of those rules or the Illinois Rules of Professional Conduct, suspend the attorney code temporarily or permanently. Board Rule 12 addresses the board's decision to conduct non-in-person hearings for the 2021 session, and this will continue until further notice. Now, I like to highlight Board Rule 13, that, and this has been an issue over the years, that a taxpayer representative should not present evidence at hearings as the submission deadline has already passed at the time of the hearing. More importantly, late evidence is not to be submitted by contacting the clerk's office. Late evidence will only be considered at re-review and only with the showing of good cause will it be accepted. Like I mentioned, Board Rule 14, which addresses certain filing deadlines, particularly for the submission of valuation evidence. Also, the submission of a brief is required, and more importantly, particularly for all income producing properties, you must submit the historical summary form and it must be completed in its entirety. Also, we must discuss Board Rule 27, which is our re-review rule, and that's analogous to a motion to reconsider in circuit court. Re-review is not a place to raise a new legal theory or factual argument. As a result, legal theories and factual arguments not previously made are subject to waiver. Also, because re-review process is not to be employed as a substitute for otherwise timely submission of documents required by the board, the submission of an entire set of documents in the first instance at re-review will be considered in discretion of the board only upon the showing of good cause. The 2021 intervening evaluation rules. Pursuant to Illinois Property Tax Code, any taxing district that has an interest in assessment that any property is overassessed, underassessed, or exempt may invoke the jurisdiction of the Board of Review to review the assessment to confirm, revise, correct, alter, or modify the assessment as appears to be just. Now, one thing that I'd just like to emphasize that is the responsibility of respective parties to exchange any and all documents with each other and not the board. As we noted in last year's presentation, we did see something that we had not seen in previous years, and that was where taxing districts were filing over assessment complaints versus under assessment complaints. Therefore, we found the need to change what we call these rules from under assessment valuation rules to intervention or intervener valuation rules. Our exemption rules were amended to include the role of interveners. Specifically, if the amount of controversy is 100,000 AV or above, any tax authority seeking intervention should file with the clerk of the board via email or in person a notice of intervention on or before 14 days from the date the taxing district received notice from the applicant that is seeking a reduction in excess of $100,000. As I mentioned earlier in my presentation, I noted that due to certain health and safety concerns for Cook County taxpayers, the practitioners, and board employees, the board did not conduct in-person hearings for the 2020 tax year. However, the board realized certain efficiencies and benefits of not in-person proceedings that would be implemented for the 2021 tax year. As many of you will recall, prior to the pandemic, we conducted the attorney hearings as well as the pro se hearings in the board's hearing room. For many, that was a challenge simply if from a auditory standpoint, where you've had a number of people speaking all at the same time and it was just very difficult to hear. Another advantage is that with the Teams application, analyst is able to share his or her screen with the advocate, which was something that was a little challenging at best to do in a hearing room. So because of that, the board has made a decision to hold all our proceedings via Teams or telephonically. And so now I'd just like to highlight just something pretty much like the checklist for oral hearings. One, they should be requested at the time of finalization of the complaint. In general, hearings be scheduled for like 8:30, which is really rare, but it's possible. 10:30, 1 and 3. Please note with the team's proceedings that the attorneys slash firms will receive an invite via email, which must be accepted in order to join the scheduled meeting. Please note that the invites are scheduled within 15-minute increments. Please note that prior to commercial industrial hearings, hearing officers review the evidentiary submissions for the current year as well as prior filings. Again, the evidence submission deadline is not extended simply by a hearing request. Documents for both hearing and desk review have the same document submission deadline. Please refer to Board Rule 13. Please note that no more than 10 cases per attorney will be scheduled for a particular call. Also, if you have a scheduling conflict, please immediately notify Ms. Rodriguez. Next, I'd like to discuss certain recommendations to improve the experience for both the advocates for the taxpayers as well as the board analysts. That will include certain attorney do's and don'ts, recommendations in regards to the filing of your complaints, evidence submissions, hearings, and lastly, attorney substitutions. I'd like to begin with a discussion regarding the attorney authorization form. First and foremost, it must be the 2021 board form, and it must be the form that's issued by the board. Please note that we posted the 2021 form last fall. No other form would be accepted. And the form must be fully executed. That means signed and dated by all parties, specifically the attorney and the taxpayer. Now, this is key. The attorney authorization form must, and I say must, be labeled attorney authorization form and nothing else. It must be indexed separately from any other form during your submission. If not, you will receive a no change 7. Our DAPS application is keyword driven, and at the time of finalization of your complaint, it does a keyword search, and one of the words that it searches for is attorney authorization form. If that form is not located within that submission, you will receive a no change 7. Now, please note that the attorney authorization form should be submitted at your initial complaint finalization. Submitting the attorney authorization form at re-review does not cure that defect. I'd like to again emphasize the importance of Board Rule 14. All parties must file their documents no later than the time period set by the board following the closing of the township for both desk, review, and hearing files. There are no exceptions. Please know that in regards to the uniform application of our rules, this must be followed. Also, again, I like to emphasize that the historical summary form is mandatory. Helpful reminder, attorney's brief should stand on its own. The brief should include description of the subject, the pen, the address, the size of the improvement, lot size, land to building ratio, age of the subject, whether or not the subject is owner occupied or leased. With Board Rule 27 or the re-review rule, the emphasis is not differences of opinion. The focus is errors or mistakes. Again, not differences of opinion. The re-review is not to reconsider previously submitted evidence. The whole objective of re-review is is to correct errors or mistakes. One thing that I like to highlight is that you should review your decision letters as soon as you receive them and immediately report any and all errors to the chief clerk. That is very important. To contact the board 6 months after a decision is rendered causes a number of issues for all parties. So it's very important that you review your decision letters as soon as you receive them, and again, immediately report any errors or mistakes. In uploading documents, it is very important that you properly identify each and every document. Again, all documents should be labeled with the appropriate title. We here at the board strongly encourage the use of the no change 8 or the administrative no change. This is particularly useful if you represented the taxpayer the previous year, the current try. You're presenting the same appraisal that the board has already considered, or you present an income approach but the subject's actual income, vacancy, or expenses are substantially the same as previously presented to the board. Regarding evidence submissions, particularly for appraisals, please upload the appraisals as one document and label it as such as board appraisal. Also, if you have the color version, please provide the color version, and more importantly, upload the PDF version of the appraisal. Regarding income and expense data, we highly recommend that you submit rent rolls that are maintained in the taxpayer's ordinary course of business and not a summary prepared by the attorney. Please complete all income expense data, and we really want income expense data that's up to date at the time of the board filing and not the assessor's filing. Please disclose the natures of your leases for income producing properties again. And what we really want to know is who's responsible for the real estate taxes. And that's really the bottom line. Now, one thing that this was more of a suggestion, recommendation, that please note that any and all board files are subject to FOIA. That being said, oftentimes you may have sensitive information in those filings, particularly it could contain social security numbers, tax ID numbers, date of birth, or financial accounts. So that being said, it's highly recommended that you should redact certain information, particularly if it's a social security number. You could just include the last 4 digits, the year of birth, for date of birth, and the last 4 digits of a financial account number. Regarding income and expense data, please note that the board has for years been consistent with the majority view for assessment bodies in the United States that real estate taxes as an expense are excluded. And it's a more detailed explanation which you all could review. But one of the things is that in essence, to avoid circularity, property taxes are accounted for in valuations for assessment purposes by adjusting the capitalization rate. Otherwise, the amount of tax affects the estimate of value used to calculate the tax. Regarding vacancy arguments, I highly recommend that you review Board Rules 21 and 22. There have been no material changes to those rules. The question often becomes, particularly when you have the property may suffer from long-term vacancy, what is the value of the property without the application of a factor to the assessor's improvement value? And that's really the bottom line, that we're just trying to determine what is this property worth. Does that, and in a lot of instances, that will require, which is very helpful, is appraisal evidence. Unique to the 2020 as well as the 2021 tax year are certain pandemic-related vacancy arguments. As you know, as of June 11th, the state of Illinois transitioned to phase 5. So as we speak, there are no governmental restrictions. When you're talking about pandemic-related vacancy arguments, one of the challenges is that for assessment purposes, our task is to value only the real estate and not the business. And also for properties that did not meet historical income streams as compared to pre-pandemic, you did have instances where the income would yield a negative net. So that raises the question of how reliable is the income approach when you have a negative net. That being said, particularly last year, we were forced to pivot and consider alternative approaches to value for properties that pre-pandemic, the income approach would have been heavily relied upon. Please note that the board does not have a flat COVID factor. And one of the things that we did do to acknowledge the impact of the pandemic, or specifically the impact of governmental imposed restrictions on businesses, is to look at effective gross income. We also looked at making certain adjustments to expense ratios and cap rates. Please review Board Rule 19, which explicitly states that all recent sales must be disclosed. It's not may, it's must. So if there's a sale within the last 3 years, you must disclose that sale and submit the supportive documentation of that sale. Regarding the valuation of residential properties, they may have a income component to it. We found that over the years that the income approach was not a reliable indication of value when looking at sales uniformity. At the end of the day, the Class 2s are subject to regression analysis, uniformity. Therefore, the income approach is given little to no weight when compared to sales and uniformity. Also, that commercial component has the benefit of the 10% level assessment versus 25. This slide is a repeat of slides that have been presented in previous attorneys' meetings. And here is just the request for the application of a market adjustment and the evaluation of condominiums and co-ops. Again, dating back to 1979, Illinois abolished the taxation of personal property. That was what was referred to in past condo or co-op analysis was a quote-unquote personal property deduction. However, that's not applicable in the evaluation of condos and co-ops. Also, I'd like to just mention there's been uh, over the years a request for vacancy relief for unsold condo units. And if you look at 9-180, there's no explicit support for that position that a developer-owned condo unit should be afforded vacancy relief simply for the mere fact that the unit has yet to sell. If that was the case, then the vacancy relief should be applied to single-family homes that have yet to sell as well. If you look, a review of 9-180 does explicitly list the conditions where vacancy relief is appropriate. We have certain recommendations in regards to filing complaints for condominiums. It's our suggestion that you file one complaint for the entire building. However, the exception would be is to file a separate complaint for the common area parcels. Regarding the commercial and industrial condos, that being the 589s and 599s, I just want to touch upon just a couple of points. One is that the commercial and industrial condos are condos with a recorded condo deck. Therefore, you must disclose recent sales within the subject building, including the PIN, date of sale, percentage of ownership, and purchase price. We have a couple of suggestions in regards to oral hearings. Before the hearing, please review Board Group 13. If this is a new client, our suggestion is that you FOIA the file and review the priors. We highly recommend that you choose your orals wisely. Oral should be reserved for unique circumstances that cannot be fully explained on the face of the pleadings. Now, during hearings, I think it's beneficial to all parties that you fully explain and disclose any change of circumstances. Please know your property, know the type, size, use of property. It's important to remember that hearings are not an extension of the evidence submission deadline. Please disclose to your hearing officer any pending assessor's recommendations or certificates of correction. Please disclose prior PTABs, SPO decisions within the TRI. And it's really important to note that don't request a hearing simply to attempt to negotiate a pending PTAB. And this was one thing that is also important. A hearing is not to discover what late evidence to submit at re-review. As a reminder, I like to just highlight a couple of the rules of Illinois Rules of Professional Conduct. One being 3.3, candor towards the tribunal, which states that a lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. Let's look at also Rule 3.5, impartiality and decorum of the tribunal. Lawyers shall not seek to influence a judge, juror, prospective juror, or other official by being prohibited by law. The communication involves misrepresentation, coercion, duress, or harassment, or engage in contact intended to disrupt a tribunal. The board found a need to highlight both rules 3.3 and 3.5 as reminders, just given what I would consider a disturbing trend in some of the tone and the language used in some of the pleadings, particularly some of the re-review requests. Now, granted, this is limited to very few firms or attorneys. However, we found it concerning enough to simply remind the practitioners of rules 3.3 and 3.5. As a reminder, I'd like to just go through the attorney substitution checklist. The board will need a fully executed attorney sub form, a fully executed 2021 attorney authorization form. We'll need a assessment complaint and also include any and all supported valuation evidence. Now, it's important to note, to ensure the proper and efficient processing of attorney subs, the packet must be emailed in its entirety to Chief Clerk Alan Manuel and not directly uploaded to the complaint via the DAPS portal. As a reminder regarding our exemption proceedings, please note for the second consecutive year, the installments have been reduced to 2 installments. The first installment is scheduled to open on about October 1st, close December 1st. Field checks will take place in the month of December. Ideally, we'll be able to forward the board recommendations to the Department of Rev by February 2022, and a second installment is scheduled to open March 1st. However, these dates are indeed tentative. There are still 3 complaints that cannot be filed via the DAPS portal, and those being the omitted assessment complaints, exempt properties, and properties where the basis of the appeal is intervention. As we have every year, we must remind the practitioners that the practice before the Board of Review is the practice of law, and this addresses the whole unauthorized practice of law issue, particularly involving consultants. That being said, non-attorneys consultants may not practice at the Board of Review. Attorneys should either be solo practitioners or affiliated with a law firm. Only attorneys may argue cases on behalf of others before the board or submit to present cases on behalf of others to the board. The board will enlist the assistance of the practicing bar to bring to light any unethical and unauthorized practice of law issues. In years past, this was generally the highlight of the annual attorneys meeting, the announcement of the towns for the first group. However, as of August 1st, the assessor has yet to publish any townships for the 21 tax year. Therefore, we don't have any towns to open. Please note that during the last reassessment of the city of Chicago, that being in 2018, the board opened 11 towns August 1st, 2018. If you have any questions, please email your questions to boardinfo@cookcountyel.gov, and the responses will be posted on the board's website. Thank you, and please stay safe.